Hello and welcome back. This is Roger Royce, partner with Haynes Boone in Palo Alto, California. And this is the 10,000 Startups podcast, where every week we bring you new original content with an industry expert on topics of interest to startup companies around mostly legal issues. And today we have one that is going to concern pretty much every startup there ever was or ever will be, and that's trademark. We have with us today Marvin Glazer. He's a lawyer here with me at Haynes Boone in Palo Alto. He's been a trademark lawyer for many years here in California and I think in Arizona.
Mostly in Arizona, yeah.
Yeah, before that. And Marvin's my go-to guy on every startup and all the trademark stuff that we need to do. So just to set the stage a little bit before we get into some of the legal aspects, I want to make sure everybody understands why this is important. And I want to give you two scenarios that are real life scenarios. I see them all the time. One scenario is where founder starts a company. They use a name that they really like, and they don't bother doing anything around trademark. And they might even have a little symbol and design, and they just go along on their merry way, building up a whole bunch of value around that name and mark, because we call it goodwill, right? People see the mark and they say, yeah, I know that company. I want to go there. It's yesterday I was up in the city and I must have walked past 10 coffee shops until I got to the Pete's, because I know what Pete's is, and so that name and that mark has a lot of value for me. So this founder, let's say, doesn't really do anything to protect it. And finally, they got all this value built up in it. And something happens where they come onto the radar of a competitor, and all of a sudden they get that cease and desist letter. It says, hey, you've been violating our trademark. So please stop and pay us a royalty, and you can't use it anymore, etc. Now, oftentimes that'll happen on the verge of a financing or on the verge of a sale of the company at a time when something has to get done quickly and the founder doesn't have a whole lot of leverage. That's a disaster. It's a disaster. Look at all that goodwill that you went all the trouble to build up, and now you don't have it anymore. It gets away. If Pete's changed their name tomorrow, I don't know, to something else, Peter's even, I wouldn't trust it. I'd say, is that the same company? So there's lots of value in those marks, especially for those of you doing internet, social media, etc. So against that background, let's dive in a little bit. So Marv, thanks for being here. Let's kick it right off and tell me, what is a trademark, or in some cases a service mark?
Right. So a trademark is a term, could be a word, could be a symbol, be a logo, could even be a sound. I'll give you an example in a minute, that's used on goods, products. And the purpose is to identify the source of those goods and who's the sponsor, who stands behind those goods, and to distinguish those goods from similar goods that might be sold by another company, another competitor. A service mark is similar, except that it's used on to promote and render services. Could be a restaurant chain, a bank, or even a Google search engine. And I mentioned sounds, the NBC chime, dum, 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 or the MGM roaring lion. Those are a registered trademark.
Can you do a lion for us?
No, I can't do the lion. Okay. And another function of the trademark or service mark is to kind of serve as a guarantee, an assurance to the consumers that they can expect a certain consistent level of quality from these products that bear that trademark, or these services that are promoted under that mark.
Okay, gotcha. So now we know what a trademark is. Let's kind of dive down into that a little bit. So let's suppose I'm starting a new company and I'm going to select a trademark. Let's start with the negative. What should I not do? What should I avoid?
Good question. There are certain marks that are considered weak marks that are difficult to protect, or in some cases impossible to protect. And among those are marks that tend to be descriptive. If it describes the function of the goods, a characteristic of the goods, the quality of the goods, they're considered weak marks and initially not meriting protection. Likewise, if a mark is misdescriptive, it conveys a quality that the goods don't have. That would be a poor choice for a mark. Likewise, any mark that tends to be geographically descriptive of the products, where they're made, or misdescriptive, where they're not made. Those would be poor choices.
So like California coffee would be a bad mark, right?
It really would be a bad mark. Yeah.
And it seems like the best marks are just kind of made up nonsensical names, aren't they?
Well,
Exxon, Xerox, Google. I mean,
right, exactly. There's a whole spectrum of distinctiveness of marks, and the examples you mentioned are the strongest marks, where you've got a coined word like Xerox that was never in the dictionary, and they made it up. It has no meaning, and the way they build up goodwill in that mark is through a lot of advertising and sales and promotion. Next, you'd have like dictionary words, like take the word Apple, used for computers. It's a dictionary word. It has a meaning, but its common meaning before Apple started using it to promote computers and phones and related products had nothing to do with the products that it was offering. Next in line, you would have suggestive marks. A good example is Coppertone for sunscreen. If you know what the product is, then you can kind of see the connection. You'll see it's suggesting a connection, but just from the mark itself, you wouldn't know what the product was. Then you get to descriptive marks. Take US Steel, which was a very descriptive mark when it was first adopted. And then finally, you're back at generic terms that are the common everyday descriptions of products like aspirin or the term faucet. You're not going to get a trademark registration. I should mention aspirin was actually once registered to Bayer for acetylsalicylic acid. And they lost their rights because they didn't police the mark properly. And it became so commonly used by everyone to refer to the product itself, no matter who made it, that they lost their rights. So you have to police your rights and your trademarks.
Yeah, well, I take one every day, the Bayer ones. Let me ask you, how does a person get these rights? Do you have to file? There's a lot of, I think, confusion around this. Do you have to file something with the federal government or even a state in order to get a right to a trademark?
Actually, to initially acquire rights in a mark, you don't have to file anywhere. You have rights at common law. Even before we had statutory registration systems, the courts would recognize that when a seller would use a mark to identify his products, that he has a right that ought to be protected at common law. And those rights would be protected at least within the geographic area where the seller was using that mark. However, you greatly enhance your rights by applying for federal registration. In some cases, you can enhance your rights through state registration, but as long as you're using the mark in interstate commerce, if you've got a website and you're taking orders, from customers outside your own home state, you ought to be entitled to apply for federal registration. It's in interstate commerce, and you really greatly enhance your rights. You get to use the circle R symbol.
Let me back up. What does that do for you if you've got a federal registration? If you get rights by using it, why would you register?
So one reason you'd apply to register is if, let's say, you want to jump the gun and start creating rights even before you use the mark. Under our current federal registration system, you can file an intent to use application. And even though you haven't used the mark yet, as long as you say that you've got a good faith bona fide intent to use the mark in the near future, and you specify the goods or services for which you're going to use it, you actually give constructive notice to the public of your intent to use the mark for that purpose. And you can actually cut off somebody else from getting ahead of you in line and applying for registration and obtaining registration for similar goods or services. Once it's registered, you get to use the federal registration symbol, the R in the circle. You have a whole body of federal rights for relief if someone infringes, including injunctive relief, damages, the defendant's profits, in some cases, even the attorney's fees. You can use it to stop the importation of infringing goods at the border through customs. And it's very helpful in terms of acquiring ownership of a domain name that someone else registered that incorporates your trademark or a confusingly similar term.
Gotcha. So backing up a second, you mentioned putting the TM legend on that.
Right.
Am I allowed to do that? If I have a name that I think is really cool, can I just put TM next to it and tell the world it's mine?
You can do that on if you put the mark on your product and you put a TM next to the mark.
Yeah.
That's perfectly fine. You're warning people that you're claiming common law rights in that mark. You can't use the R in a circle until you actually receive your certificate of registration.
Okay, gotcha. All right. That's an interesting distinction. So that's something, I mean, what are the, if you do, how bad is it? I mean, is it?
Well, yeah, in theory, people can sue you for falsely representing to the public that you've got registration. In addition, at some point when you're applying for federal registration, you need to submit specimens showing how your mark is used. And if your specimens have the R in a circle next to your mark, even before you got it registered, they'll give you grief for that as well.
Okay. So let me ask, how does somebody know if they'll start using a mark? How do they know? I mean, I guess we can do a Google search, but beyond that, how do they know if somebody has rights in a mark or a name that they want to use, and that those rights are really close to the business that the founder wants to conduct? So they're going to have problems if they use the mark. Is there a way to figure that out before we put a lot of money into it?
There is. And at the very least, if somebody comes in and says, hey, I want to protect my trademark, the first thing we do is conduct at least an initial screening search on the U.S. Patent and Trademark Office website, uspto.gov. They have a very powerful search engine. You can find any active issued federal registrations and any pending applications for federal registration for identical or similar marks. You can see what goods or services the other party has registered the mark for or has asked for registration. Then you can analyze whether there's likely to be a conflict or not. Am I going to have trouble persuading the trademark office to register my mark in view of the people who are ahead of me in line? Sometimes it'll even give you a hint as to how you ought to define your goods or define your services in a way in your own application to avoid a conflict with the other party. Sometimes conflicts can't be avoided, and in that case, I'd probably tell the client to consider using a different mark.
Use a different mark.
Yeah.
Now, is that what they call a knockout search?
Yeah, it would be a knockout search. Now, if a company were going to launch a new product, they had a lot invested, they're going to be doing a big advertising campaign, you'd want to do more than an initial screening search. You'd want to do a very comprehensive search, including common law directories, state registrations, internet searching, probably even foreign searching. And, the cost may go up, maybe, even $2,000 or $3,000, but it's a lot easier to change your mark before you launch the product than it is after you launch the product.
Sure. So on that point, do I get foreign protection if I register a mark here in the US?
No. Every country has its own trademark registration system that extends with it its own borders. And if you get a mark registered here in the US, and now you find out that somebody in Europe or in Japan is using a confusingly similar mark, that's not going to help you. You can apply for registration in other countries, similar to the way that you would do here in the US. What we often take advantage of is the World Intellectual Property Organization, WIPO, has an international treaty or convention, the Madrid Protocol, It allows you to file a single application. You can actually file initially in a division of the U.S. Trademark Office, asking for international registration. You designate which countries are of interest to you. The fees are based on how many countries you designate. That application is examined preliminarily by the International Bureau at WIPO, and then it's passed along to each of the designated countries that you've indicated.
Mhm.
They do their own searching, and they each have the right to grant protection or refuse protection in their own country. It's a particularly if you have a lot of countries involved, very cost effective. You don't initially need to engage a foreign associate, and it's a very good system.
Okay, great. Okay, now let's suppose the founders come and they've talked to you and they've been forewarned. So they register their trademark and they go through that process. And now they've got their certificate. They've got their federal registration.
Right.
Are we one and done, or do we have to think about this ever again?
No, you can lose your rights even if you've registered the mark. And I guess the most important consideration, you have to keep using the mark. You have to keep using the mark in interstate commerce. If you stop using the mark, you can abandon your rights. And if you stop using it for more than 3 years, there's a presumption that you've abandoned the mark. Now, even if you keep using it, you still between the 5th and 6th anniversary of the registration date, you've got to file a declaration showing the trademark office that you're still using the mark. That's called a Section 8 declaration. You also have the right at that same point to request that the registration be made incontestable. And that's a declaration under Section 15. If you can say that your usage has been exclusive, there aren't any pending proceedings trying to remove your rights from the register or contesting your right to have the mark on register, you file that declaration, there's a small additional fee, and now your registration becomes incontestable. And the last thing that you need to keep in mind is that every 10 years, you need to apply for renewal. And as long as you're still using the mark, you can renew it every 10 years.
Gotcha. Now that incontestable, does that mean that nobody can come challenge my mark?
Well, there are certain very limited grounds if you've abandoned it and they can show that you haven't used the mark for the past, 3 years, or there's other circumstances showing that you've abandoned rights. They can cancel the mark or petition to have it canceled. If there was fraud involved in initially obtaining the registration, that could still possibly be raised as an issue. But very, very limited grounds for trying to undo the registration at that point.
Okay. So let's say we don't quite get to that point yet. We get the registration, we find out someone's infringing.
Right.
What does this trademark allow us to do or keep other people from doing?
Right. Well, you would, let's say a client came to me and said, hey, one of our competitors is using a similar mark. What should we do? The first thing we do is evaluate how are they using it. The standard that you apply, is there a likelihood of confusion? That's the same standard that the trademark office uses when they decide whether you're entitled to registration in the first place. It's also the standard that a court would use if it had to decide whether there's infringement. Is the public likely to be confused? You'd look at things like, comparing the mark, their mark to your mark. How similar are they? Do they sound alike? Do they look alike? Do they have similar meanings? Are they being used on related goods or services? What channels of trade, what customer bases are they being directed to? Are there any cases of actual confusion where maybe one of potential customers come to you thinking that they were dealing with the other party or vice versa? So if it looks like there's a likelihood of confusion and you've confirmed that your rights are prior to theirs, they didn't start using it until after you applied for registration or after you started using your mark, at the very least, you'd send them a cease and desist letter. If that's non-responsive, you can file a civil action in the federal district court.
Okay. All right. What happens if because I know this does happen, we go to register the mark and we find out somebody else is also claiming rights in that mark? Who wins? How do we decide that?
So Usually it's determined by who was first to use.
First to use,
First to
not the
use.
file.
Yeah. Now, if the other party was first to file, they essentially give you constructive notice as of their filing date that they're claiming rights in that mark. That might not be enough to prevent you from continuing to use in the geographical area where you are already using it, but you might be then locked in to that area and you won't be able to expand.
Okay, gotcha. All right, so it's important to, I guess, know what's out there.
That is true. That's why we always want to do a search.
Okay, so now I've got the mark, nobody's infringing, I've established my rights, and I want to let somebody else use it and pay me a royalty. Can I
Okay.
do that? How do I do that?
You can do that, and trademarks and service marks are licensed all the time. The license agreement should be in writing. It should have sufficient terms to carefully specify when the mark may be used, what types of goods it may be used on, what level of quality needs to be associated with those goods, because you don't want the public to be defrauded about relying on a trademark when there aren't sufficient quality controls. And you certainly don't want injury to the reputation of the brand if the other party misuses it.
Right. Yeah, so the quality control, that sounds like an important one. You're letting someone use your mark. You want to be careful what they're actually going to do with it, right? What product they're going to sell.
And that's true. And then many times you'll insist that they give you prototypes or samples of the product, sometimes periodically, even after it's launched. So you can take a look at it, make sure that it's up to snuff.
Yeah. Well, you're known by the company that you keep, so quality control is important.
Right.
I guess the last question I'd ask you about is how do we assign these things? And let me tell you exactly what I'm thinking about. Every once in a while, I'll find somebody that went and got a trademark before they incorporated, or we do an M&A transaction or something where the mark has to get into a corporation, and sometimes they have only an application when they incorporate. So are these rights assignable?
In general, yes. The only exception is if you've got pending an application based on the intent to use. So you haven't used the mark yet, but you've got your application pending. Generally speaking, an intent to use application cannot be assigned before the mark is used. Now, once the original applicant has started use of the mark, they can file an affidavit of use or statement of use with the trademark office. And at that point, you can then execute an assignment, record a copy of the assignment in the trademark office, and then the mark and either the pending application or any issued registrations can be assigned. And the only other thing that I would want to stress is that you cannot assign trademark rights in the abstract. Sometimes people just, well, I'm assigning my rights in the mark, and we call that a naked assignment. Naked in the sense that it's devoid of the goodwill of the business that it symbolizes. So the only way you can validly assign a trademark is together with the goodwill of the business that it symbolizes. Often that means that the assignor will provide product labels, maybe some manufacturing machinery, the website, the domain name registration, other things that go along with the use of that mark and the goodwill that it embodies.
Yeah, and once you start down that path, I know we have to worry about crossing over the line where you're actually selling a franchise, which is closely related to trademark licensing, I know, but that's a little beyond the scope of today.
And beyond my expertise, and that's why we bring in a franchising attorney at that point.
Yes, we do. Okay, well, Marv, I want to thank you for being here and kind of summarizing the rules around trademark. That was really instructive. I think this is good information for our startup founders. Protect your rights in that mark. It's valuable and you need to keep it. This is Roger Royce, Haynes Boone, Palo Alto. I've been talking with Marv Glazer here about trademark law, and we'll see you next time.